The Congress gets to determine the day in which the electors of the president get chosen, okay, basically election day, all right? They get to do that just to make sure that the election happens across the country all on the same day, right? But that's about all they get to do. The rest is in the hands of the states. We'll cover that in a minute. Okay, eligibility for the president. Okay, so in order to be a president, you have to be a natural-born citizen, okay? Now, either that or you have to have been alive at the time that the Constitution was ratified, which is not going to be a problem anymore, right? Because it's over 200 years since the Constitution was written. Okay? Let's talk about the inauguration, okay? On the approximately the 20th of January, the president, after he's been elected in November, the president's going to give his inaugural, he's going to take his inaugural oath, and he swears to, I do solemnly swear or affirm that I will faithfully execute the office of the President of the United States and will, to the best of my ability, preserve, protect, and defend the Constitution of the United States. So that's his oath of office. So his allegiance an oath to the Constitution, so that's his primary duty. Okay? Okay, let's talk about the Electoral College. Now, this slide here just kind of shows you all 50, the Electoral College is sort of like a process, okay? Each state gets electors, and the number of electors that a state gets is equal to the number of congressmen they have, as well as the number of senators they have. You add them together, that's the number of electors they get. Washington, D.C. as well gets 3 electors. Okay, so you can look at this real quick, and you can see all the states have, you know, California is ridiculous, they got 55, and my home state, Pennsylvania here, has 20, okay? So you can find your state and see how many electors you get. So, the way in which the electors are chosen is up to the states. Now, in today's day and age, pretty much every state will have their electors be chosen by the public. So you go into the voting booth and you see, you want to vote for Joe Smith and Harry Douglas. They're all on one ticket. When you click that button and choose that ticket, you're really choosing the electors that support that ticket. You're not actually choosing the president. You're choosing his electors, okay? Now, the Electoral College has an original process, and it was also amended in 1803. And I want to take you through the original process, and then we'll look at the way it was amended, okay? Now, what happens is, on the day that the Congress has determined, each state has their electors meet, okay? And they vote by a ballot. You know, originally they voted for 2 different people, okay? And at least one had to be a non-inhabitant of the state, okay? After everybody, all the electors had chosen 2 people, the list of names and the number of votes each name got was placed on a certificate, and it was sealed, and it was sent off to the Congress, okay? Now, in the Congress, the President of the Senate, in a joint session, that means both the House and the Senate were convening at the same time. It's a joint session, right? They would open up the certificates and they would count the votes for each state. Okay? And the president was determined by the largest vote count, right? Whatever person throughout the country got the most counts in all the states would become president, provided he had a majority of the electors. So what does that mean? If you look if you look at all the electors that each state has, and you add them all up, you get like 538 electors, right? So it takes 270 votes to win the presidency, okay? Now, if you had at least 270, you would, the Congress would determine that, yeah, you had a majority, right? So if you have a majority, you can win the presidency. But if you don't have a majority, then what happens? The House of Representatives will handle the situation. So here's a couple of scenarios that can happen. You could have more than one person with a majority, or you can have nobody with a majority, or you can have one person with a majority. If you have one person with a majority, it's easy, he's president. If you have two, then the House of Representatives would take those two and decide by voice vote, or by vote, which one was president. If nobody had a majority, they would take the top 5 names on the list by the number of votes that they received, and they would choose president off of those 5. Now, here's the catch. When the House of Representatives broke the tie, they didn't break it by members. They broke it by state. So what do I mean by that? So I just said earlier, California has 55 electoral votes. Pennsylvania has 20, right? Well, when the House of Representatives gets in there and they decide they're going to break the tie of the presidency, it doesn't work that way. Each state gets one vote, okay? And it requires at least 2/3 of the states be present for the vote, and one vote per state, and the winner is president, the runner-up was vice president. And that's the way it used to work. Now, if there was a tie for the vice presidency, the Senate would break that tie. And that makes sense because one of the roles of the vice president is he becomes president of the Senate. So it makes sense that the Senate would be involved in a tiebreaker for his vice president. Now, in 1803, there was a change in the process. It wasn't a big change, but it has a big impact, okay? And what they did was, they said, okay, instead of just having the states name 2 people, we're going to have the states name president and vice president. Separate the lists into 2. We'll have a president list and we'll have a vice president list. So now the runner-up for presidency doesn't become the vice president. That's very interesting because I'm going to show you the tie-breaking rules are pretty much the same. The only major difference is that if nobody had a majority of votes, they would only take a look at the first 3 for president instead of 5. And of course, the Senate still gets the tiebreaker and whatnot. Okay, but let's take a look at this. This is a slide I really want to look at. You can see early in our history before we had the change to the electoral college process, you're going to see here that people from different parties were in the executive branch. So you had John Adams was a Federalist, right? Thomas Jefferson was a Democrat-Republican party, right? 2 different parties. And so the interesting thing about that is that, I'm just doing myself here. Yeah. The interesting thing about that is that, the more divisive the country would be politically, right, the better chance you'd have of 2 different parties in the executive. So now, imagine, do you think Hillary Clinton would have gotten away with what she got away with the, with the business over in the Middle East, with the, the terrorist attack on the 9/11, where the executive branch Americans were killed by the terrorists over there, and what was it, Benghazi, right? Do you think she would have got away with that if they had 2 different parties in the executive, right? The vice president's like he's like a watchdog over the president in this scenario, right? Now, after 1803, when this process was changed, you could see that we no longer had this scenario, right? First 3 administrations we had it. And then here, all of a sudden, in 1864, we have it again. And that's kind of interesting because what happened was there was a party created, National Union Party, right here. This National Union Party. This was Abraham Lincoln's attempt to run for re-election in the middle of the Civil War, and he picked a Democrat in the South to run with, so they created a party, a National Union Party. They ran together. So they were actually elected on the same party, but they were really, in fact, one was really a Republican, the other was really a Democrat. So it's an interesting, but that process of 1864, that's the first time the president and the vice president ran on a ticket as, you know, as a, well, it might not have been the first time, but it happened ever since. Let's put it that way. It was ever since Abraham Lincoln, now the president and the vice president run together on the same ticket, okay? And with that scenario, you're not going to have a split executive branch. Okay, let's talk about the war powers. So, we all know Congress has the power to declare war, I hope, correct? Now, the executive, the president, he's going to be the commander-in-chief of the Army and the Navy of the United States and of the militia of several states, but only when they're called into the actual service of the United States. What does that mean? It basically means that the militia, which is supposed to be the bulk of the military, is to be controlled at the state level, and the president is only commander-in-chief of the militia once the Congress has declared war, or maybe there was some kind of an emergency and the Congress had some kind of emergency act, right? But the Congress has authorized the president to use the militia. Then they still have to go to the governors and request them, okay? So this means that while the president is commander-in-chief of the Army and Navy, he doesn't get the entire military at his disposal for, for war games. I mean, he has to have specific authorization to use the military. Now, the founders' philosophy on war. I like to say that it's the Congress's job to break the peace, okay, and it's the president's job to restore the peace. Okay, so the Congress is the body that's closest to the voter, right? So they're the ones that should be choosing whether or not your sons and daughters go to war, or whether you go to war, right? And once they've made that decision, then it's the president's job to take the military, use it to our advantage, get us a good situation when it comes time to establish the peace. If we're going to do a peace treaty or whatever, obviously the job of the president is to win a war, so that when we sit down and negotiate the peace, we get to dictate the terms of the peace. So that's how I see it. That's how the philosophers saw the founding philosophy was, and I could show you that. Here's a quote from Hamilton. This is in Federalist number 49. Now, he says, the president will have only occasional command of such part of the militia of the nation as by a legislative provision may be called into the actual service of the Union. So, the King of Great Britain and the Governor of New York have at all times the entire command of the militia within their several jurisdictions. In this article, therefore, the power of the president would be inferior to that of either the monarch or the governor. Okay? And again, here's another quote by Hamilton. This is in 49. It's only a couple paragraphs down from there. He says, the president is to be commander-in-chief of the Army and Navy of the United States. In this respect, his authority would be nominally the same with the King of Great Britain, but in substance much inferior to it. It would amount to nothing more than the supreme command and direction of the military and naval forces, as First General and Admiral of the Confederacy, while the British King extends to, while that of the British King extends to the declaring of war and to the raising and regulating of the fleets and armies, all which by the Constitution under consideration would appertain to the legislature. So if you look at, powers of the Congress, you're going to find that indeed they get to raise and regulate the militia, and they get to set the rules. They get to, set the parameters around how they're trained and whatnot. Okay, so. Now, on standing armies, Hamilton mentions in number 8, and I don't want to quote all of number 8, it's pretty extensive, but if you read what Hamilton has to say in Federalist number 8, I'm going to take a set here, because it's going in and out on me. If you look at what he has to say in number 8, he says that, you know, if we didn't have a central constitution, chances are these various states are going to start to war with one another. And when these states have disputes and they start to war with one another, they're going to have rather large standing armies, right? They're going to have to be prepared for war every day. So their understanding, their belief was that if the Constitution were to be ratified and the 50 states were to have a common defense, then they wouldn't be at each other's throats. They would have a federal government that would help them alleviate any difficulties they might have amongst one another, and they wouldn't need a large standing army. And so they would just have the militia system, right? The people would be trained within the states to serve the state's interests, but they wouldn't need to have a standing army. And the reason they were really concerned about a standing army is because it was the standing army of Great Britain that was in their homes, right? At the time of the Revolution, it was a standing army that was in their homes, right? We read about that in the Declaration of Independence. So they believed that the Constitution would require a small standing army just for repelling insurrections and whatnot. But they were very, very afraid of standing armies. Okay. Okay, a couple other things the president can do. He can get the opinion of his principal officers on different topics that are specific to that person's job. He might have the treasurer give an opinion on, whatever treasurers do, right? They're all economists, I guess, right? He shall have the power to grant reprieves and pardons for offenses against the United States, except in cases of impeachment. Okay, so he can't pardon an impeachable offense, but he can pretty much he can pardon a lot of other stuff. Okay, Article 2, Section 2, Clause 2. In here, the president has a few tasks that he takes care of along with the Congress. Specifically here, we're looking at the treaty power, which I'm going to cover on Friday. I think Thursday or Friday. I'm going to give a talk on the treaty, so I'm not going to go into deep detail on that. He shall also nominate and, by and with the advice and consent of the Senate, he shall appoint ambassadors, other public ministers, councils, judges, officers of the United States, blah, 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 right? So he can nominate, but he can't just appoint anybody he wants. He can nominate, and he needs the Senate approval to do so, to make the appointment stick. However, the Congress can determine that certain appointments can be handled either by the president himself or by the courts or by heads of departments, okay? The inferior officers listed here, it says, but the Congress may by law vest the appointment of such inferior officers. It's not really well defined. What we do know is the inferior officers would not be considered heads of departments, and they would not be court members. Okay. Now, the president can fill up the vacancies if the Senate's not in session, but those appointments would be temporary, right? And they would have to be renewed at the next session. Now, something interesting happened. In 9/11, 2001, 9/11, right? We had that terrorist attack happen, and what did Bush do? Bush created the Department of Homeland Security, right? And when he did that, he got around to reshuffling the entire executive branch. He took, various departments like the Treasury and the Interior and other departments like that, and he moved them underneath Homeland Security. Now, when he did that, he gave the Congress the excuse to allow him to appoint some of those positions that traditionally required Senate approval. And because now they weren't considered department heads, they were under Homeland Security, they could be, the Congress could allow him to appoint them without their approval. So here's what we got. We've got the Senate realizing that it had somewhere between 1,200 and 1,400 appointments that it had to rubber stamp. So they came out with the Presidential Appointment Efficiency and Streamlining Act of 2011. They always make it sound good. There was 162 executive positions, 2,536 public health service officer positions, 319 national oceanic and atmospheric administration officers, a couple CFO positions here, one for the transportation and one for Treasury. CFO is Chief Financial Officer, so they were dealing with the money. Not critical appointments, right? They're just dealing with your money. 3,017 total positions were no longer required state, or no longer required the Senate confirmation process, okay? Now, we were assured at the time that none of the positions that were covered in this Streamlining Act were going to be controversial positions, all right? Well, let's take a look at some of the non-controversial positions. The Treasurer of the United States no longer requires Senate confirmation. 2 Assistant Secretaries of the Treasury, 6 members of the National Security Education Board, the Director of Selective Service. If you don't know what the Selective Service is, at 18 you're going to have to register for Selective Service because that's the draft board, basically. 2 members of the Council of Economic Advisors. We got the Deputy Administrator of the FAA, Federal Aviation Administration. That's the airlines, okay? 2 State Department Assistant Secretaries, Assistant Secretary of the Department of Labor, 4 Directors of the Department of Justice, and 4 Deputy Directors of the Office of the President, okay? All right, let's finish up on the President. So he gives a State of the Union address, right? The State of the Union address is, the way it's written in the Constitution, it's not required to be annual. It just says from time to time, the President shall give an account of the State of the Union to the Congress. Now, George Washington, he set the precedent. He did a formal talk in front of the Congress, and he did it pretty much every year. In fact, he did it every year. And after him, that process actually fell out of favor. A lot of the presidents wrote to the Congress. They just sent, their report written to the Congress. But in the 20th century, probably, I would estimate Wilson administration, it became tradition almost that the president now give a formal address every year. Okay, but it's not constitutionally required, so it's interesting to know. The president can convene both houses or either of them. So, if there's a problem and he needs Congress in session, he can call them in. He can adjourn them as well, but he can really only adjourn those houses if they can't decide amongst themselves when to set closure, when to end the session. Then he can step in and say, okay, well, your session's ending next Friday or whatever. Okay. He can receive ambassadors and other public ministers, and he should take care that the laws be faithfully executed. Now, I highlighted the word faithfully here because, again, he's taken an oath of office, right? His oath is to the Constitution, so he needs to faithfully execute the laws of the United States, meaning he needs to execute them in such a manner as to fulfill the intentions of the Constitution. Okay. Let's see. He's also going to handle all the. He's going to commission all the officers in the United States. That's going to be the military positions. Okay, let's talk about impeachment. The president, the vice president, and all civil officers of the United States shall be removed from office on impeachment or for and conviction of treason, bribery, and other crimes and misdemeanors. Now, you'll notice there's two words here, right? We've got impeachment and conviction. Okay, so obviously impeachment is not conviction. So what is impeachment? Okay. This slide here is going to compare impeachment to a criminal case. You're probably all pretty much aware what goes on, in the criminal courts, right? So the impeachment really is a piece of legislation, like a resolution, that's passed by the House of Representatives, and in it charges the president or some other official with certain violations. And if enough votes are received, then the official's going to be impeached, right? Now, once the impeachment occurs, that's basically like a grand jury indictment. Now they hold a trial in the Senate, and the Senate acts as the jury. And if the president is the one being charged, then the Chief Justice presides over the hearing or over the court case. Otherwise, if it's some other official, the Vice President will preside over it. Obviously, the Vice President, they don't want the Vice President presiding over a president's trial because he's got, skin in the game, right? So, all right, real quick, we're going to go into, how am I doing on time there? How am I doing on time?
20 minutes.
20 minutes? Okay, thank you. So we're going to look at Article 3, the U.S. Constitution. This is the judiciary. Okay, this is very interesting because a lot of people don't realize. Now, we have a lot of federal courts, okay? But the only court that the Constitution calls for, that the Constitution requires creation of, is the Supreme Court. All the other federal courts that are underneath the Supreme Court, they're all considered appellate courts, and they're all under the control of the Congress. They're created and they're destroyed at the whim of the Congress. Okay? A justice, a judge on a court, he's not appointed for life. Everybody says, judges are appointed for life. Judges are appointed during good behavior. That means they can be removed from the bench. Also, courts can be demolished. So you can get rid of a judge without even impeaching him. You just get rid of his court. Just dissolve his court. Okay? Let's see. A judge's pay shall not diminish during the continuance in his office. Okay. We need to talk about jurisdiction. Okay? Jurisdiction is one of those kind of strange words, but what it basically means is it's the geography and the issues that a court or some other office has reign over. It's the dominion. Okay, and there's two main principal types of jurisdiction when it comes to courts. There's what's called original jurisdiction. That's cases that by their nature belong to that court. And then there's appellate jurisdiction. And appellate jurisdiction are cases that court is empowered to hear on appeal from a lower court. Okay? When it comes to the Supreme Court, its original jurisdiction involves cases surrounding ambassadors or other public officials, and it also covers cases involving a state with controversies surrounding two or more states, or between a state and a citizen of another state, or a state and a citizen of a foreign state, or the state or the foreign state itself. In other words, if the case is crossing state boundaries or it's crossing national boundaries, okay, that's where the Supreme Court's going to have its original jurisdiction. Except Article 3 was amended by the 11th Amendment, in which it was written that The judicial power of the United States shall not be construed to extend to any suit in law or equity commenced or prosecuted against one of the United States by citizens of another state or by citizens or subjects of any foreign state. What does that mean? Basically, that means I live in Pennsylvania, I sue the state of New Jersey. Because it's me, because I'm a citizen of a state and I'm suing another state. My case is not within the jurisdiction of the federal government. That means I've got to go to a New Jersey state, I got to make my claim, I take the ruling of the state of New Jersey. Now, I may be able to, if I don't like the ruling, I may be able to appeal it to a higher court within New Jersey. But once I get to the Supreme Court of New Jersey, that's it. The federal government has nothing to say on the matter, okay? Now, appellate jurisdiction involves cases involving the Constitution, the laws of the United States, treaties, and the Supreme Court shall have appellate jurisdiction both as to law and fact, with such exception and under such regulations as the Congress shall make. Okay, so the appellate jurisdiction covers the Constitution, the laws of the United States, and treaties. Now, let me ask you this. How many of you have been told that the Supreme Court is the final arbiter in determining what the Constitution means? Yeah, we've all heard that, right? Well, here, according to this, according to Article 3, Section 2, Clauses 1 and 2, the Supreme Court doesn't have original jurisdiction in matters of the Constitution. Think about that. If the Supreme Court doesn't have original jurisdiction, if it can only hear it on appeal, and if the Congress is empowered to determine the rules around the appellate, like they can limit the appellate jurisdiction of the courts, well then obviously the Supreme Court's not the final arbiter as to what the Constitution means, right? Because the Congress can tell it, you know, you got no business ruling here, or you have no business ruling there, or you're not going to hear that case, right? In fact, any of you that are involved in the pro-life movement, I know a lot of Christians are involved in the pro-life movement. One of the missions that I believe that we have is to explain to these the leaders of these groups, if they don't already understand, what we need is we need the Congress to declare that the Supreme Court will have nothing to say on abortion. Okay? And once that happens, then there's going to be cases galore being raised in different states to oppose the abortion industry. And then we're going to find out, you know, once we've made it clear that the Supreme Court's not going to overturn state rulings, then we're going to find out which states are going to allow it and which aren't, and we'll wait and see how that works, because, you know, what do they say? Competition breeds excellence, right? So you'll see how many people move and, you know, to different places where they want it or where they don't want it, and blah, 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 right? So we'll let the states deal with it. Okay. Let's see. Criminal cases. All right. The trial of all crimes, except cases of impeachment, shall be by jury. Okay? And shall be held in the state where the said crimes shall have been committed. When not committed within a state, the trial shall be at such place or places as Congress may, by law, have directed. Okay, so if you commit a crime in Pennsylvania, the case is going to be held in Pennsylvania. If you're out on the middle of, if you're on the Delaware River, right between, and they can't determine if you're on the Pennsylvania side of it or the Jersey side of it, okay, then maybe the Congress will determine where your case is when you committed the crime. If you're out on the high seas, Congress is going to determine where your trial is. If it's an internet crime and it covers 16 states, well then maybe the Congress will determine where your case is. All right? Article 3, Section 3, they define treason. Our founder said that levying war against any state, adhering to the enemy, giving him aid and comfort, no person shall be convicted of treason unless on the testimony of two witnesses to the same overt act. Okay, to the same overt act. So you can't have one guy say, yeah, well, I saw him do this, and someone else said, well, I saw him do that. No, you have two people, you have to witness the same exact act. It has to be considered an act of levying war or of adhering to the enemy or giving the enemy aid and comfort. If that's, if that's what two witnesses can testify to, then you can be found guilty of treason. The Congress is going to have the power to declare the punishment of treason, but there's not going to be an attainder of treason that's going to work to the corruption of blood. What does that mean? That means that if your dad's convicted of treason, that you're not going to be judged because of it, right? It's your father that was the, that was the criminal, not you, right?